Good morning, Nick Dogle, North State Law. Appreciate everybody joining me today. I hope everybody had a happy holidays and a great new year going forward. Today we're going to be discussing attorney misconduct. Thankfully, I do not participate in attorney misconduct, but I do know my ethics rules, so we're going to jump right in. There are three main ways that an attorney can be disbarred. There's obviously way more than just three, but we're going to touch on kind of the big three, as you would say. First one is trust accounting / misappropriating clients' funds. When an attorney does retainer work, which is not flat fee, they do basically keep the money in a trust account for a client, and they do not touch it until they actually earn that. Keep up to date on what goes in, what goes out, when it goes in, when it goes out, how much goes in, things of that nature. What it's used for, what time was used for billing, things like that. So that's one of the main things. Any attorney that I know that uses a trust account is very meticulous about that. I would recommend, and the bar recommends, reconciling a trust account once every month, at the end of every month. They say that you can get away with doing it once every 2 months. I do it once a month. Every attorney that I know that I've spoken with that has a trust account does it every month. So that would kind of be my rule of thumb. Another area is client confidentiality. And one of the main things nowadays with technology is you got to consider cyber attacks and people stealing clients' data off of your cloud-based system, or if you have a network, off of your network, or whoever you keep the client's information. That goes back to client confidentiality. It's not just saying, hey, I know John Smith because I represent him, here's everything to know about his case. Yeah, don't do that. That's pretty obvious. But also make sure that you keep the information as protected as you possibly can. Now, if somebody is way ahead of cybersecurity and they're able to hack into, the Department of Defense or something, and you've done everything a reasonable attorney could to keep your client's data safe, and they end up getting that information, you might be okay. But you have to do reasonable measures to protect your client's information. That's required by the bar now. They teach cybersecurity classes as well, CLEs. So if you need a little bit of refresher on that, maybe need some CLE courses, that's not a bad way to go about getting that and getting good information that's useful. So the last one that's kind of above the big three is substance abuse. I've had the displeasure of actually seeing an attorney give up his law license. That was when I practiced in Mississippi years and years ago. This individual, it wasn't his first go around with substance abuse issues. He had previously did what's called a non-adjudication on a cocaine case in the 80s. Well, fast forward to 2009, he gets in a car wreck. Police see some crack cocaine in his glasses. He ran from the scene. They kind of let him go at that point. 2010 rolls around. He actually gets caught up in a sting operation at a flea bag motel with some ladies of the night and, again, some crack cocaine. So this individual had a major problem. Instead of putting him in custody as far as throwing him in prison, he was given, again, probation. And part of the plea deal, which happened right in front of me, was that he gave up his law license. So needless to say, it was an eye-opening experience. I saw firsthand the impact somebody that has a substance abuse issue can have on not only their life but their career. That's the other main thing. The Bar Association has substance abuse classes. The State Bar has classes as well. There are also programs, CLEs. Every attorney has to have a substance abuse CLE once every 2 years. So anyways, sorry to end on such a down note, but we'll be back next week. If anybody has any questions, feel free to reach out to me, North State Law. You have a good day. Bye-bye.